Michigan has a moderately regulated breaking lease framework with a statutory duty to mitigate and specific local variations in Detroit and Ann Arbor. The governing law includes Michigan's landlord-tenant statutes and the Truth in Renting Act, found in MCL 554.631 through 554.641, along with general contract principles. If you're a landlord or tenant in Michigan, the state provides a workable statutory framework, while local ordinances in certain cities add complexity. Let's start with the landlord's duty to mitigate damages. Michigan law requires landlords to make reasonable efforts to re-rent a unit when a tenant breaks a lease and vacates. This duty is established through Michigan case law and reinforced by the state's general contract principles. The landlord cannot leave the unit vacant and hold the departing tenant liable for the full remaining rent without making genuine re-rental efforts. The landlord must take reasonable steps, advertising, showing, and accepting a qualified replacement tenant. The departing tenant's liability is limited to rent during the vacancy period, plus reasonable re-rental costs. If the landlord fails to mitigate, the departing tenant's liability is reduced by the rent the landlord could have collected through reasonable efforts. Michigan's Truth in Renting Act adds an important consumer protection layer. The Act prohibits certain lease provisions that are considered unfair, including provisions that attempt to waive the tenant's rights under the Act. A lease provision that eliminates or waives the landlord's duty to mitigate could be challenged under the Truth in Renting Act as an unfair provision. This means the mitigation duty exists regardless of what the lease says. Early termination clauses are generally enforceable in Michigan if they are reasonable. A clause requiring 30 to 60 days notice and a fee of 1 to 2 months' rent is typical. The fee must represent a reasonable estimate of anticipated damages. Michigan's Truth in Renting Act and the Michigan Consumer Protection Act provide tools for challenging fees that are excessive or unconscionable. Michigan's Clean Slate Act, one of the most comprehensive automatic expungement laws in the country, is relevant to the breaking lease context indirectly. When a landlord is re-renting after a broken lease, the replacement tenant screening must comply with the Clean Slate Act. Automatically expunged records cannot be considered when screening replacement tenants. Military members have the right to break a lease under the SCRA. Michigan's military population is relatively limited. Selfridge Air National Guard Base near Mount Clemens and Camp Grayling are the primary installations. However, the SCRA applies to any service member renting in Michigan. Michigan has enacted protections for victims of domestic violence and sexual assault that allow early lease termination. Under MCL 554601B, a tenant who is a victim of domestic violence or sexual assault can terminate the lease by providing written notice and documentation to the landlord. The qualifying documentation must include a copy of a personal protection order, a police report, or a written statement from a qualified domestic violence or sexual assault service provider. The tenant must provide at least 28 days written notice, or may leave immediately if remaining poses an immediate threat, with rent owed through the date of departure. When a domestic violence victim terminates under this provision, the tenant is responsible for rent through the termination date, but is not liable for rent for the remainder of the lease term. The landlord cannot charge an early termination fee. The security deposit is handled according to standard rules, returned within 30 days. Michigan's provision includes important protections regarding the perpetrator. If the victim and the perpetrator are both on the lease, the victim can terminate their individual obligation. The landlord can then pursue lease enforcement or eviction against the remaining tenant, the perpetrator, if they violate the protection order or lease terms. Tenants in Michigan may break a lease if the landlord fails to maintain habitable conditions. Michigan recognizes an implied warranty of habitability in residential leases. The landlord has a duty to maintain the premises in a condition fit for habitation, including compliance with building and housing codes and maintenance of essential systems. If the landlord fails to address serious deficiencies after receiving proper written notice, the tenant may terminate. Michigan does not have a detailed statutory repair and cure framework with specific timelines like some states. The standard is reasonableness based on the circumstances. The tenant should provide written notice, allow a reasonable time for the landlord to respond, and document the conditions and communications before terminating. Michigan also recognizes constructive eviction. If the landlord's failure to maintain the property or the landlord's affirmative actions make the unit uninhabitable, the tenant can treat the lease as terminated. The tenant must vacate within a reasonable time. Detroit has enacted local tenant protections that may affect breaking lease situations. Detroit's Fair Chance Housing Ordinance and other provisions create a more regulated environment. Landlords in Detroit should verify current local requirements. Ann Arbor has local source of income protections and a progressive political environment that supports additional tenant protections. From a practical standpoint, Michigan has a large and diverse rental market with dramatic variation across the state. Detroit has the most complex market. Revitalized neighborhoods like downtown, Midtown, Corktown, and Woodbridge have strong demand with quick re-rental, often within 2 to 4 weeks. Other parts of the city have softer demand with longer vacancy periods. The contrast within a single city is dramatic. Ann Arbor, home to the University of Michigan, has one of the tightest markets in the state. Student demand drives quick re-rental during the academic cycle. Mid-year breaks take longer but are still manageable given the overall market strength. Grand Rapids has emerged as one of Western Michigan's strongest markets. Re-rental is typically quick in desirable areas. Lansing has a moderate market driven by government and Michigan State University. Kalamazoo has a university and healthcare-driven market. The Detroit suburbs, Troy, Royal Oak, Farmington Hills, Novi, Dearborn, have strong markets. Flint and Saginaw have softer markets where re-rental takes longer. One best practice for Michigan landlords: verify that your lease does not contain provisions that violate the Truth in Renting Act. A clause that waives the mitigation duty or imposes the full remaining rent as liquidated damages without mitigation is vulnerable to challenge. Structure your early termination clause to work alongside the mitigation duty, not replace it. Another best practice: begin re-rental efforts immediately and document every step. Michigan's case law-based mitigation duty means your documentation proves reasonableness. A third best practice: have a standard process for handling domestic violence terminations under MCL 554.601B. Accept the documentation, process the termination within 28 days, handle the deposit within 30 days, and maintain confidentiality. Michigan limits the security deposit to 1.5 months' rent. The deposit must be returned within 30 days of the tenant vacating. If the landlord fails to respond within 30 days, the landlord may forfeit the right to retain any portion. These rules apply to broken leases and normal move-outs alike. For the complete guide to Michigan breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.